Welcome to another episode of Electable. I'm Deb Chubb, and I'm here again today with Destiny Scott Wells, our resident legal expert here at Indiana and working on Democratic politics, also deputy chair for the state Democratic Party for coalitions and expansion. And I just cannot give you enough credit for the work you're doing in that area. That is close to my heart. The collaboration and coalition building is something that I think the biggest thing I took from Stacey Abrams' experience in Georgia, and I think is so important and is so valuable and could make such a difference in Indiana. And you are really doing great work to promote that. So you're awesome. So, but today we are here to talk about reproductive health rights. So I kind of feel like, just don't get me started. I have been working on this issue. I am old and I have been working on this issue for decades in Indiana. And it keeps going backwards is the problem. So many women who are young don't realize what oppression, what physical risk comes with illegal abortions, and so don't really appreciate how important this is. And of course we have over the years advanced many birth control methods that are much more effective and can be used and hopefully avoid abortions, but abortion still has to be there. This is, and in my opinion, this is I'm sorry, I'm Destiny. Can I just say first, welcome to the show.
I'm always happy to be back. No, you keep going, Deb. I mean, because you mentioned earlier my position with the party in building coalitions, and we were just all on a call last night together, weren't we? Trying to get women organized because we've been talking about that this is coming. So we're not just talking about this. Some days it may feel like we're talking about it in an echo chamber, but it is an issue that is going to be at the forefront of next year's legislative session, and it's going to, I hope, galvanize women into action. So in order to do that, we both talked about being able to understand just what exactly is going on. And so I'm happy to be here to talk to you about it.
That's great. So, and I'm just going to start right off with my argument about women's right to abortion. I consider it an equal protection issue because no firefighter, no soldier, no police officer, no doctor is required by law to risk their own health or their life, or to risk their own financial security to save the life of another being. Only pregnant women are being required by law to give up their financial security, to risk their health, which is, of course, as you know, in this state, it's safer to have a child in the West Bank in Israel than it is to have a baby here in Indiana. So the risk is not insignificant, and to risk her life to save this other human being that no one is going to care about once it is born. So to me, this is an equal protection issue, and of course now it's become comical when people are running around saying, you can't make me wear a mask to protect somebody else's life. Really, but you can tell a woman that she has to risk her health to protect a potential other life. So, okay, they're okay.
Right, and we see that with, recent statements by the Indiana Attorney General, Todd Rokita. And we're really not going to talk much about him today, but, that the sun won't set, he says, right before Indiana goes or files or whatever in response.
Oh, and he did a tweet saying, we will protect Hoosiers' right to make their own medical decisions. Like,
Right.
okay.
Right. Unless it is a woman, because then a woman shall be subjugated to his political dogma. And so that's where we are. That's the reality we're in. So what do we need to do?
Right. Oh, so that, and of course that brings up, and we want to get it out there right away, about October 2nd, this coming Saturday, all over this country, there are marches being planned to go out and demonstrate your will to fight more further oppression of women and their reproductive decision-making all over the country. So I know there's one in Indianapolis, there's one in Fort Wayne, of course there's one in Washington, D.C., there's one in Vigo County. So they're everywhere. So look locally, find your local demonstration and get out there and, be heard, be counted, make sure people know that you are ready to fight for this. So,
right.
Okay.
10:30 a.m. And because women are not fickle, masks are required. And we're all absolutely fine with it. Outdoors, mask required, 10:30 a.m. Downtown Indy, I believe, at the State House.
Excellent. Okay, so let's get into the nitty gritty a little bit. So this has all really come to a head now because of the Texas law, SB 8, that was enacted at the state level. And then, of course, there was an attempt to enjoin the implementation of that. And then the Supreme Court did something that they've been doing more and more of, which is kind of bizarre. And so I'm going to ask you to explain first the law, SB 8, because it, of course, it's brand new idea, very different. And of course, no one, I think, is really even, got their head around the possible implications of this kind of law. And then I want you to talk about what the Supreme Court did about it.
Sure. I do want to point out that I went to law school in Texas at UT Austin. So I often talk to Texas attorneys who are my classmates, and I would say things leading up to SB 8, like, well, I always tell people, at least it's not Texas, or I would say, look at SB 8, this is crazy. And they would say, oh, don't worry, there'll be an injunction. They weren't really sweating it. Now I talk to them and I say, thanks, Texas. Thanks, because this thing is catching like wildfire as to red states and what they may do in their next legislative session. So Texas SB 8 bans almost all instances of abortion after 6 weeks. The law contains no exceptions for pregnancies that result from rape, sexual abuse, incest, or even pregnancies that involve a fetal defect that is to the extent incompatible with life after birth. So that woman is expected to carry that child full term, that fetus. And so it applies to anyone who performs or induces such an abortion. We'll call it a prohibited abortion. Anyone who knowingly aids or abets one of these abortions. So that raises questions like, to what extent could services that provide education for abortion fall under this? So it could, it hypothetically, and I think actually already is showing that it has this chilling effect on abortion services and education. And then anyone who intends to perform or aid a prohibited abortion. There was recently an article by a healthcare provider where he intentionally violated the law, kind of sent out a test case saying that he would provide abortion services. And I will put a pin in who the first plaintiffs that stepped up were, because it is comical. And so what this law does is it relies on the ordinary citizen to bring forward a case. Normally, it would be the state's executive branch that would enforce the law in Texas and everywhere else, but Texas has decided to pretty much deputize any citizen. Doesn't even have to be a Texas citizen, to really serve as a bounty hunter to root out these cases. And then you have lawyers that are involved that, will help pro bono, just depending on what side of the issue they're on, right? So I would imagine the doctor felt safe in doing this. He's probably going to have pro bono legal services. However, if you bring forward the case, you can get up to $10,000 for a claim.
In addition to attorney's fees? Can't remember now. I think it might be.
So and that is really the kicker, right? So the person that bears all the expense, even winning the case, really is the defendant. I mean, because the plaintiff doesn't have to incur those attorney's fees.
Right.
And why did they do this way? They did it because they're trying to end run judicial review. And so, what is judicial review? That's where the Supreme Court can step in. Well, a court can step in and determine the constitutionality of a law and strike it down if they don't think it's unconstitutional. So by end running this and evading judicial review, it's really kind of amounts to what is a legislative, a scheme, basically a scheme.
Well, and part of it, it's that there's no state action, right? So lawsuits, against the government in enforcing this law require, you have to have state action for it to be, applicable, and everybody look at it to get standing. And so now there's no state action. These are just private people doing it. So, although a lot of people are saying that, there will be some level of state action just to make this thing work. And that might then allow judicial review, like you say. So, but yeah, it's a crazy thing. Crazy thing.
A legislative scheme, as the words of the Attorney General, Merrick Garland.
Right. So, okay. So then two things happened. It was enjoined, but then the Supreme Court did this interesting thing. So tell us about that.
So they took up the case in an odd way. They ruled from what is called the Shadow Docket. So Whole Women's Health, you see them often as a party in these cases, protecting women's reproductive freedom, and they ask for this Texas SB 8 to be halted because they cannot provide abortion services that are constitutionally afforded to women. So the Supreme Court hears it from the Shadow Docket. The Shadow Docket it's been around for a while, but it's really gotten a lot of attention lately because the Supreme Court is using it a lot more. So when they take up a case on the Shadow Docket, they hand down an order or summary decision that does not receive a full briefing and oral argument. And we see it used often with like politically charged emergency relief. Procedurally, this is done from the calendar that they use to issue their case management orders. And they are able to do this without really giving a substantive opinion when they hand it down. So you can see an opinion issued and it's not even signed and doesn't say anything. So what happened was the Supreme Court issued this unsigned opinion from that docket, and it allowed SB 8 to stand. So the Supreme Court will say, well, we didn't rule as to the constitutionality, it's just as to procedure, but Texas SB 8 with this order, I mean, it doesn't say anything, yet it circumvents the rights of thousands of Texas women in receiving abortion services.
Right, and implements a clearly unconstitutional law.
Right.
It is shocking. It is just shocking that this has happened.
And the irony is, as much as it's shocking, I guess it shouldn't have been, because the frequency that we see this court use the Shadow Docket, these opinions, they were handed down, I believe it said 4 times between the Bush and Obama administration, but with the Trump administration, they did it 28 times. 28 times. And these are often hotly debated policies that go into effect without being fully litigated. And then the Supreme Court is at odds with the lower court's findings. And then another thing to point out is that, when we look at abortion, and you look at it compared to any type of religious liberty argument, the Supreme Court never rules on those from the shadow docket, right? They aggressively intervene. They're fully briefed and argued. But with abortion, they were just very quick to issue this. And, the shadow docket actually has some relevance to Indiana. If you look at when the shadow docket was most recently used, it was in a case called the United States versus Dustin Higgins, and it was an execution, federal death penalty statute case. And basically what happened there was Higgins was sentenced to death in the early 2000s in Maryland, but there is a statute that basically says that offender is to be executed in a manner prescribed by the state. So while he was sitting there on death row, Maryland abolished its death penalty. And so when it came time for him to be executed, there was no manner prescribed as by the state that he was found guilty and sentenced of this crime. And so at the very end of the Trump administration, the Supreme Court heard the case and ruled from the shadow docket and totally went against the lower court's findings that, this could be illegal. And Higgs ended up being executed at the 11th hour of the Trump administration, with just days before President Biden took office. And that happened, that was the 13th execution during the Trump administration. So that just shows, these highly politically charged issues are being ruled on from that docket.
Yeah, so we're going to have a whole nother discussion about, what we do about that. So in the meantime, then Department of Justice stepped up. Merrick Garland, U.S. Attorney General, said, we're going to step in here and we're going to protect women and their right to seek legal abortion. So, and his position was basically like, states cannot implement unconstitutional laws. Is that right? Is that your reading? Yeah. And what happened was, because everybody was like, wait, this can't be, there's always supposed to be an injunction. There's supposed to be a stay granted, and we're actually subject to this. Like, women are going to have to drive from Texas. Texas is very, very big. Heaven forbid if you're pregnant in West Texas and need an abortion. And so, what is the federal government going to do to save us from this procedural end run of judicial review? So on September 2nd, President Biden made a statement that he was going to consult DOJ, and then it happened very quickly. By September 9th, DOJ files a case against Texas to completely overturn SB8. It didn't attack just little pieces of SB8. It wants the entirety of it declared invalid. It also is seeking a preliminary and permanent injunction against enforcement and for costs to be awarded. So, now we're all waiting on the injunction. But until then, Texas abortions are pretty much still illegal right now. And when they filed this, they filed it, on a couple different grounds.
three specifically. So first, the Supremacy Clause in the 14th Amendment, saying that Roe and Casey guarantee women's right to abortion up to viability. That's about 24 weeks. By federal interpretation, I think the state of Indiana, it's like around 22. Secondly, that the federal law preempts the state to act. And third, this pretty genius argument that there is an intergovernmental immunities exception. So what does that mean? It means that a state agency can't interfere with what the federal government mandates. So, if you have a federal facility that provides services to rape or incest victims, then there's a question if a private citizen, these quote unquote bounty hunters, can bring a private action against a federal employee. And so that would also violate the Supremacy Clause. So that's what they're arguing, and to turn it over completely.
Excellent. Okay, now the question becomes, what about here in Indiana? It was not, the ink wasn't dry on the Supreme Court procedural ruling from the Shadow Docket before Senator Liz Brown here in Indiana said, yeah, I'm going to be submitting that very same law here in Indiana. Of course, our Attorney General Todd Rokita said, "Oh yeah, I'm with you. We're gonna impose this kind of a law here in Indiana." And I don't know if other legislators are jumping on board or not, but I suspect they will. So, so that would come in January of 2022. We don't know what's going to happen yet as far as DOJ being able to really crush the law in Texas. And we don't know, frankly, even if the DOJ is able to crush the Texas law, whether it will require another action by the DOJ to do it in Indiana, or will, whoever the scary people are who are manipulating the law in however they can to punish women, will find some tricky way to change this law in Indiana such that it does not fit exactly into the ruling that the DOJ is seeking now, and so that we have to fight this all again. So now what?
Well, and as there are, I didn't mention it earlier, but the first plaintiffs out of the gate are disbarred attorneys.
Right.
Which is a really absurd thing, right? One, I think, is in prison. I mean,
yeah, he is in some custody of some sort,
they've empowered people to sue doctors from prison over a random woman they do not know, most likely getting an abortion. The other one is a disbarred attorney from, I think, Illinois.
I think it is Illinois. Yeah. So, and it was kind of funny because both the defendant in this case and the attorney who's suing him both said, they were making the point of how ridiculous this is, that a disbarred attorney who is in some kind of state custody can sue, and the doctor who is being sued also saying, look how crazy this is. A disbarred attorney could, can sue me and right. is entitled to $10,000 plus attorney's fees.
Right. And so in all the absurdity, somebody like Senator Liz Brown out of the Fort Wayne area thinks it's a great idea to say, well, we plan on doing this next session. And actually there was that whole question there in limbo, like people were a little on edge. People in the know that care about the rights were a little on edge because it was right before redistricting in Indiana. And so they were wondering if when session reconvened, if the special session, if they were going to take up abortion. They didn't, but if you'll notice, and I'm just throwing it out there, Liz Brown's district has now been pretty insulated, pulled out into a more rural area, and she now has a safer seat by most accounts. So they didn't take it up, only did redistricting.
Well, have they ended the session yet?
No, but Senator Bray, the Senate pro temp, has went on the record saying that they will not be taking anything up but redistricting. Some people were thinking maybe there'd be a floor amendment issued, but Yeah, we didn't see
Right.
that. And
It is,
so
but something else happened in Indiana. So, but go ahead and finish your thought.
no, go ahead.
So, okay, sorry. So here's the other thing that happened. Indiana, passed its own laws that restricted women's access to abortion rights. The federal court, the federal district court,
Oh yeah.
struck down many of those and enjoined them from taking place. And then the federal appeals court, the Seventh Circuit, it sits in Chicago, reversed that. So these laws that had been passed in Indiana were suddenly now legal again. Well, legal,
Right.
but
We
they're
talked about
implemented.
that last. It was like I said before, Whole Women's Health. So it was Whole Women's Health versus Rakita and a couple other defendants. And yeah, we were super happy and celebratory on the last call
Right.
because we thought that there was a positive outcome. And AG Rakita said that they would appeal immediately. And that opinion by the appeals court, by the Seventh Circuit, was 2-1. So 2 men and then 1 woman dissenting, Judge Diane Wood. And, she has a record of dissents that basically call out her counterparts. And she did the same one in this, dropping in a footnote that said her colleagues were extensively tinkering with the text to achieve their outcome. But I
and the point being that we need women in positions of power who can make these decisions, and we just don't have enough of them.
Right.
That is the point.
Well, we have a lot of Trump attorneys now too. So I mean, Trump judges. We have a lot of Trump judges too now.
That's true. You're right.
Unfortunately.
And so I will just kind of read through the list just to kind of remind people what those new restrictions are that were shot down and now are back up. They are that only physicians can perform chemical abortion. So chemical abortion is just when you used to give somebody a set of pills and they go home and they take those pills.
55% of Indiana abortions are chemical.
Right. And so only a doctor, not a nurse practitioner, or other trained healthcare professional must give that pill to the woman. Of course, so that means more expense, more time, more, limited staff to interact with women who are seeking this. Another one is that only hospitals and ambulatory surgical centers can provide second trimester abortions, not a well-equipped staffed clinic. Patients have to receive an in-person counseling before an abortion, which means, of course, that you have to have a second appointment. So a woman has to go in, have a counseling session, and then go home and then come back again, take another day off of work. Patients have to receive in-person physical examinations before an abortion. So again, that's an additional appointment, another day off work, another day to find childcare for her children, and of course, another travel expense. And then also that medical staff have to do all these services in person, no more telemedicine for prescribing and talking and doing the counseling and the prescribing of the chemical abortion pill. And of course, this is, the only medical service that is specifically not allowed to be handled by telemedicine. So many other things, counseling services, other doctor appointments, follow-up appointments, doctor interviews with patients, all of that is fine to be done via telemedicine, but not the doctor interview, discussion, and counseling of a woman who's seeking an abortion. So, so here we are, and it's bad, and it could get worse. So this, I don't know, I spent a lot of time being so super just angry about all of this. And I will be out there somewhere on Saturday screaming my head off. And I encourage everyone to do that. But as you know, my biggest ask is that women run for office. This is really the only way to allow a legislature to view women as full citizens. Only if they have fair representation in the legislature. And we are, woefully underrepresented, less than 25% in Indiana. So that's my big push. We need to do that. We need women.
It doesn't even have to be a Texas SB8 style bill that goes forward in January when session starts, because Dobbs v. Jackson will still be heard. It'll be argued on December 1st of this year in front of the Supreme Court. That's the 15-week ban on abortion coming out of Mississippi, which, violates the constitutionality of, that women can receive an abortion up to viability again without state interference. So it will be basically questioning Roe v. Wade and Casey, and probably should expect that at minimum it will be chipped away at. And so because that law will, or those cases will be heard and then an opinion issued in late spring, summer of 2022. And we've spoken about this before, that we anticipate anti-women's reproductive freedom legislation to be put forward in the Indiana General Assembly. So whether that be the Texas SB8 style bill that Senator Liz Brown speaks about, or just your typical Representative Peggy Mayfield-led legislation that she puts forward pretty much every year, that's litigated pretty much every year, and costs the taxpayers every year, will be put forward. So Roe v. Wade, I want to end on this. Our Indiana Women's Democratic Coalition is going to do an event third week of January, because that coincides with the 49th anniversary of Roe v. Wade. And it's late enough in January that we'll probably have a good idea of what bills are being put forward, and just short of the filing deadline to run for office. So
good. Yes, so good. Okay, great. Well, thank you so much. This is just heartbreaking topic. And it's so infuriating. It's so diminishing of women's being and, full citizenship, on the planet, to be tossed around in this way it's just heartbreaking. And we just can't have it. So of course, as I said before, please find a local event in your community. There are happening all over the state and in Washington, D.C. But also think about running for office. Please think about running for office. I have worked with women running for office for a few years now. I mean, I've worked on many women's campaigns over many years, but when I really went out and recruited and really talked to women and really tried to convince women to run, one of the most common responses was, I'm not qualified. I don't know enough. And I just want to say to women, if you really think you are not qualified, find a woman who is. And it's not that I think that you are not qualified. I think that will make you realize that you are qualified yourself. So please run. And guess what? There are a lot of us out here who want to help. And we are ready to wrap our arms around you and help you run, help you file, help you run, help you campaign. And we really have to have more women. There's no other way to do this. There just isn't. We have seen that. So, all right, that's my last spiel. Okay, Destiny, any other great words of wisdom for us before we go?
See you at the march.
Excellent. See you there. Be counted. All right. Thanks again, Destiny. We will see you next time.